This lecture would appreciate the meaning and concept of agency. We are going to discuss what is the meaning of agent, who can be agent, and what is the contract of agency and its implications. So first of all, we are going to see what is the meaning or the concept of the contract of agency. The contract which creates the relationship of principal and agent. Any contract which can create a relationship between two persons, one is in a position of a principal and the other is acting as an agent, then such a contract which bound these two persons is termed as the contract of agency. A contract of agency is always between two persons. At least minimum two persons should be there. The principal is a person who can hire someone to act on his behalf, who is termed as agent. So there can be one agent or there can be more than one agent in a contract of agency. Agency connotes a relationship existing where one person has authority or capacity to create a legal relation between his principal and third parties. Here it is defining that an agent is actually a person who is authorized by the principal to act on his behalf and to create a legal relation which can bound the principal who has employed him and any third parties to whom they are with whom they are working. So contract of agency is dependent on the principle that two persons are working with each other, where one person has authority to act on behalf of the other, and that other person is bound by the authority given to his agent. There are certain rules of agency, and first of all is transfer of valid authority. What is meant by valid authority? Term valid authority means that a principal can authorize his agent to do all those things over which he himself has authority. If he don't have any authority on the subject matter which he is transferring his agent to sell it, for example, then that subject matter, if it is not belonging to or in the ownership of the principal, cannot be sold by the agent or cannot be worked with by the agent, as the agent cannot do a thing or cannot have a power over which the principal was not having power by himself. What is the exception to this? Contracts involving personal services or skills cannot be transferred, or the authority cannot be transferred to agent to act upon or to do all those acts which are actually personal services or skills of the master or the principal. For example, marriage, one cannot authorize another person to go and do marriage or go for marriage to a person to which he was actually engaged by himself, or to sing in a concert in which he was actually contracted by the parties, or he has already contracted to sing in that function. Similarly, no one can paint for another's behalf, and no doctor can perform any operation on behalf of someone else or on the patient of some other doctor as the other doctor has authorized him. So valid authority also have exception, that if the authority to be delivered or authority to be handed over is a something related to personal services or specialized skill of that person, and the principal was engaged due to his specialized skills, now such principal cannot hire an agent, cannot authorize his agent to perform that act on his behalf. Number two is binds the principal. Acts of agents may be enforced in the same manner and will have the same legal consequences as if the contract had been entered into and the acts done by the principal in person. Meaning thereby, when a principal authorizes his agent to act on his behalf, he himself binds himself that if in any case any complication arises or any consequences arises, he would behave in a manner that he himself has done this thing. As the basic principle behind this contract of agency is that agent is authorized to do whatever principal can do himself. So if agent do something, it would be considered that principal is doing this thing by himself. There are some basic ingredients of the contract of agency, and first ingredient is that agent has power on behalf of principal to deal with third persons so as to bind the principal, meaning thereby that agent is authorized, properly authorized by the principal to deal with others as if principal is himself working with these people, and he is given authority to do all those legal acts which are required to be done while dealing with third parties, and all those acts which are authorized or which are required to be done for the benefit of that deal with third parties would be binding on the principal as if he was dealing with all those persons by himself. The second ingredient is subject matter of agency. Subject matter of agency has to be dealt with as the property of the principal and not of the agent. Whatever would be the subject matter of agency, whether it is a movable property or immovable property, whether it is in the shape of goods or land or some building or some vehicle, it would be considered that same is actually the property of the principal. If anything happened to that subject matter or anything defective appears in that subject matter, there would be no consequences for the agent, as the principal has given that subject matter to his agent to work with. So, subject matter of agency has nothing to do with the agent. Third ingredient is that agent acts as intermediary for consideration. Agent is an either intermediate person, and he works for gain, and he works for the benefit of the principal because he is rewarded by the principal for this act. He is hired as an employee by the principal. So agent is acting as an intermediary for consideration. Fourth point is the liability of agent is always the liability of the principal. As we have already discussed in previous points, that as the authority or the power given to the agent is the authority or power of the principal. Similarly, subject matter of agency is actually in the ownership of the principal. So, how can be the agent liable for anything if done or happen to that authority, which can be defective authority, or to that subject matter, which can be defective, and it is found that the authority was not validly transferred because the principal himself has no authority to hand it over to his agent. So if any liability arises, that would be considered as the liability of the principal, and there would be no consequence for the agent. There are certain characteristics of this contract of agency, and number one is agreement between principal and agent, meaning thereby that in contract of agency there should be an agreement between principal and agent. There should be at least minimum two parties who are under an agreement to do something, and that agreement is contract of agency. Number two, agent must represent his principal and must act on his behalf. Agent is a person who is working for gain or working for reward as an employee of employer, and principal is paying his agent to work for him or to represent him and to do all the authorized acts on his behalf. Number 3, principal must have contractual capacity. If principal is contracting with someone and hiring someone to work on his behalf, that principal should have contractual capacity to engage his agent. Number 4, consideration is not deciding factor. If sometime it appears that in the contract of agency there is no consideration to be paid for to agent, or there is no consideration between the principal and agent, so one cannot say that as this agreement is not having consideration, so this is not a valid agreement. So in contract of agency we have learned that consideration is not the deciding factor to conclude this agreement as a proper valid legal agreement. Number 5, agent has power and capacity to make the principal answerable to third persons. When agent is working on behalf of principal, then he is authorized to work in that manner by the principal. So agent has capacity to conclude his deals on behalf of principal with third persons, and his all the dealings would be authorized expressly and impliedly by the principal. So all the acts of the agent would be considered as the acts of the principal. Therefore, he has capacity to make the principal answerable to third persons, as the acts of the agents are considered as the principal was himself available at the time of deal.